Okay, for this live stream, we're gonna just get right into the court audio transcripts. There will be no paperwork or none of that to show. I want you guys to just pay close attention to how Douglas Hanson is now using these two officers from the Salem Police Department to help him prosecute me. I, in fact, went through what's called a bench trial with the Honorable Susan Tripp. Um, Susan Tripp, I forgive you. I know that this wasn't you're doing. I knew this was Douglas Hanson taking advantage of your pre-existing condition. So I do take that into consideration. I just pray one day that you go to the Judiciary Board and you ask for the clemency that you rightfully deserve. Only if you choose to turn in Douglas Hanson. You got to give something to get something, as the Honorable Judge, what was her name, Aubrey Boyle said to me. You got to give something to get something back in return. So I hope that you really make a decision in your heart to go after Douglas Hanson and hold him accountable for him taking advantage of your mental capacity as an honorable judge. I know that some stuff is private and some stuff is not supposed to be on the courts, for the courts, and it is your duty, Tripp, that if you suffer from some type of mental illness that cause you not to sit up on the podium as a judge, then it is your ethical duty to recuse yourself. And like I said, I forgive you because I know you wasn't the main person after me. It was Douglas Hanson. So in this video, we're going to solely focus on the trial because this is a trial. Douglas Hanson like to say that I didn't get trialed. I wasn't trialed. I was forced into taking the plea bargain, which is actually absolutely the truth. So what we're going to do is live stream the court audio transcripts. But before I press play on the court audio transcripts, I want to let everybody know, and Douglas Hanson and the judicial courts know, that I am not aware of any stipulated protective order which hinders me and stop me from releasing my court audio transcripts to the public. So with that said, I'm going to press play and the
Thank you. Please be seated. Thank you. Hold on. There we go. State wishes to call the case.
Yes, thank you, Your Honor. This is State versus Matthew Mayfield Johnson Jr., 14C 42686. Defense counsel Gail Ryder is present with the defendant who is out of custody, Doug Hanson for the state. Your Honor, this is the time and date for a continuation of the motion to suppress that started last week on the 26th. It's my understanding that the defense had called a doctor to testify. That was just the brief testimony that was given at that time. It was cross-examination by the state. And then we are continuing the motion to suppress as well as deal with some other motions in regards to venue. The state is ready to proceed. We have two officers that are ready to testify.
Ms. Ryder, anything further for the record before we begin?
Nothing for the record, Your Honor.
All right, thank you. Call your first witness, please.
Thank you, Your Honor. The state calls Roger Smith.
Sir, if you'd stand right there, please raise your right hand. Under penalty of perjury, do you swear or affirm the information you're about to give in this court and cause shall be the truth?
I do, Your Honor.
Have a seat.
Thank you.
Once you're seated, state your entire name, spelling your entire name out for the record.
Yes, ma'am. My name is Detective Rogers Smith. My first name is Rogers. Last name is Smith.
Counsel.
Thank you, Your Honor. Mr. Smith, you indicated you're a detective for which agency?
Salem Police Department.
And can you tell us how long you have been employed by the Salem Police Department?
It's been a little over 9.5 years, sir.
Can you briefly describe some of your training and experience in law enforcement training and what you're doing currently?
Certainly. Started off my law enforcement career like everyone else does. I go to the police academy. There they have a whole gambit of training from everyday interactions with the public to DUIs, basic drug investigations, sex assault investigations, domestic violence, regular assaults and thefts, things of that nature. Post-academy, for 2 years I was a certified drug recognition expert, knowing the signs, symptoms, and physiology and effects of drugs and alcohol, specifically drugs, on a person and how it impairs their body, for drug-impaired driving investigations. I've had training on highway interdiction, mostly the idea of large amounts of drugs moving up and down the highway and how to talk to the driver and discover those in control or concealed spaces and traps within vehicles. Further training has been done through the El Paso Intelligence Center. They're a large group of intelligence gathering out of El Paso, Texas. The Desert Snow or Black Asphalt group, which again does like drug interdiction and narcotic type investigations. I've had training through the Oregon Police Officers Association regarding drug investigations, human trafficking, most recently at the Oregon Narcotic Enforcement Officers Association in Bend, where actually I think it was Eagle Crest this past year. I think that's most of it.
Okay. Detective, can you tell us, are you currently working like a unit called like street crimes?
Yes, sir, I am.
Tell us about that, please.
Street crimes primarily focuses on street-level narcotic-type investigations, drug complaints in drug houses. Those, like drug complaints or the drug houses, will come from the schools, come from regular neighbors and citizens. Anyone that sees something out of the ordinary, sees high traffic coming to and from a house, will go out and do considered a knock and talk. Basically knock on the door and see if the individual will allow us in to either find if there's any validity to the complaint or if it's kind of like a neighbor dispute. Past that, we also do, again, like the street-level narcotics, individuals selling small amounts of controlled substances, and a livability issue. We also focus on human trafficking investigations or prostitution investigations here in the local area, where we can go online to certain websites such as Backpage and make contact with females that are involved in prostitution, and then make dates with them and subsequently arrest them and those involved with those.
Detective Smith, have you had an opportunity to do those types of investigations involving promoting prostitution during your career?
Yes, sir, I have.
And is it common then for you to set up some sort of a meeting, as you said, at a hotel or somewhere local with that potential prostitute?
Absolutely.
Did you end up having contact with who you became to know as Jessica Johnson in one of your investigations?
Yes, sir, I did.
And tell us how you first met Jessica Johnson online.
On the evening of May 15th, I was looking at Backpage.com. Like as I said, it's a very common website that women involved in prostitution will use under the escort section.
So is it somewhat like disguised as a legal type of a situation as an escort service, but you find in your investigations that it really becomes a prostitution situation?
Yes, sir.
Okay. Go on, please.
Looking through that escort section, found one ad that was posted on the evening of May 15th, I believe around 4:30 to 5 p.m. that night. And looking at the advertisement, I could see it was an Asian female, multiple different photographs, and various poses and amounts of clothing, limited amounts of clothing. There was a phone number listed there, which using a program that we have to send text messages, began a series of text message conversation with this female in the attempt to elicit a response regarding sexual intercourse or prostitution.
So it goes without saying, Detective, that you don't actually tell the person who you are and that you're an officer.
No, actually, it's more often than not they will ask if we're a cop. Are you affiliated with law enforcement anyway? And it's actually very common for that to be on the ad itself. Saying that by contacting me, you're entering into a contract in which that you're not involved in law enforcement or the police of any kind, which is also an indicator that there's something not necessarily legal if it's just a simple massage.
And so tell us then about the time and date and place, how you set up this meeting with Jessica Johnson. What was she known as online?
At that point, she was known as Kalina Yamamoto, and I did a little bit of research on her that evening. There's another website called TNA Board, which is a website for women involved in prostitution and then men that are their clients or Johns, where they can write reviews about one another. The women that are is their term, providers, the prostitutes themselves, can go on and look and see what reviews this person has had. And I did look that up, and she had multiple reviews. She had a profile listed there with the services that she provides, typical times and amounts that she'll allow. That evening on May 15th, we didn't have enough resources available. Essentially, we didn't have enough detectives to make a proper investigation and do it safely. And so I had to put it off until the following day on May 16th.
How did Ms. Johnson react to that?
We had initially set up a date a date meaning we'd agreed upon a price, we agreed upon our services.
And what were the services that she was providing to you?
She told me full service. During these conversations via text or phone call, it's not going to be, will you have sex with me for $150? There will be certain code words or slang such as full service. Full service is a very common term meaning intercourse, full intercourse sex.
Is this based on your training experience that you've come to know what these terms mean?
Yes, sir.
All right. And so what were some of the other terms that she had used?
MSOG.
What does that stand for?
Multiple shots on goal. That
What
essentially,
does that mean?
it means that during, say if we're going to be together for an hour, she will allow me to ejaculate more than one time within 1 hour. As long as I can do it within that 1 hour time frame, it'll be covered under, $100, 1 hour. I can come as many times as I like.
All right.
Or as I'm physically able to, I guess.
Okay. Any other terms?
May I refer to my report?
Absolutely. Do they also talk, and I know this is somewhat crass, but they talk about how many holes?
Yes, they do. Miss Johnson, her exact words when I quote, $250 an hour, full service with Greek. Greek is a very common slang term for anal sex. Or $350 an hour, 3 holes MSOG. That means for the extra $100, making it $350 for the hour, I can do all 3 holes, meaning both anal, vaginal, and oral, and then I can basically ejaculate as many times as possible within that.
All right. And so you, because of lack of resources or personnel, had to reschedule the time to meet with Ms. Johnson. Did you reschedule that for May 16th of 2014?
Actually, I didn't reschedule it that night. I left it as, I'll give you a call when I get back into town. I get back into Salem. And then I didn't have contact with her again that night. However, on the morning of May 16th, I noticed that she had reposted a new ad at about 7:40, 7:50 that morning, on the morning of the 16th. Seeing that, and it was still within the Salem section. Having seen that, I realized she was more than likely still in town, and so I reached back out to her, essentially apologizing for kind of flaking out the day before, and then offering, maybe $50 extra if she would see me and kind of give me a second chance. if she was willing to do that.
Now, you said in the Salem area, is it common for these women to go from city to city and post at different times and different locations where they are and what they're willing to do?
Yes, sir, it is. Even under the back page portion of the escort section, you will have at the very top of the page, it will say Bend, Eugene, Corvallis, Salem, Portland. I think there's some of the coast cities there, but you can essentially follow a girl from city to city. And even if there's a search section right below where the cities are, you can put in, say, their first name, and it'll bring up any ads that they've recently posted. Or if you can't find something in Salem, I can type in an ad, and it will show me, I can't find anything here, but here's some nearby ones, and you can find them, say, in Portland or in Eugene or Corvallis.
So when you recontacted Miss Johnson on the 16th, then was she willing to meet with you?
She was. She upped her price, though, to $420 an hour, still for the 3 holes in MSOG. And she said that we had a deal at 1 o'clock.
How do you determine where you're going to meet these women?
It can be several different ways. Sometimes they will tell you to go to a part of town, or I'm in the Hawthorne Market area, or I'm just in Northeast Salem. On this occasion, I told her that, I'll give you a call around 12:15, and you can tell me where you are. On this occasion, Ms. Johnson actually said, okay, I'm at the Shiloh Inn on Market Street. So it was very easy for me to find out. She told me exactly what hotel she was in.
And so do you arrange then a specific room to meet her in? How does that work?
Again, most times with that is they will, from my experience, you'll show up in the parking lot and you'll shoot them a text message that says, hey, I'm here. They'll either call you or they'll have you call them so that they can actually hear your voice. And they'll do that for a couple reasons. A lot of times they will have windows that face parking lots so that they can see that you're by yourself, or they watch you drive in. They look for other vehicles that are driving in along with you, and they see 7 to 8 guys getting out of a minivan. It's probably a clue that it's not just a normal date. On this occasion, she told me to call her when I got to the parking lot. And when I did that, she told me she was in room 319.
What time of day or night was this?
Our date was at 1 p.m., and when I called her the final time, it was at 12:53 p.m.
Did you arrive by yourself then in a vehicle into the parking lot?
I did. We had actually had an advance team that went out. Several more detectives drove out about 45 minutes prior.
Is that common in these situations
It
to have
is.
an advance team?
Yes, sir.
Tell us what that team does.
Big part of it is, one, to look at the area, see if there's anyone that kind of stands out as a suspicious that maybe is watching the parking lot, that looks like they are looking for cops. Also, if we all showed up at once, like I said earlier, one person showing up by themselves and then having 2 or 3 cars or one minivan show up with a bunch of guys, that's a clue that something's just not right. So we'll have them go out first, and usually maybe 2 other vehicles, and they'll mix into the hotel. Most of the hotels, we have a very good relationship, and they will allow us to borrow a room for a little bit so that we can kind of stage there. And then when we have the final location to go to, then we'll filter down and meet at that room.
I assume all the vehicles that you and your advance team are using are unmarked patrol vehicles of some sort.
Yes, sir.
You were not in uniform, I imagine?
No, sir, I wasn't.
Undercover?
Yes, sir.
How about the advance team? Are they in uniform or not?
Typically, they're not in uniform. However, they will take a backpack or some sort of bag that will conceal any of their duty gear or their body armor and things like that, so that they can try and look as normal as possible when they walk in.
So then tell us about how you, when you first physically met Miss Johnson in the hotel room.
Walked up to room 319 and knocked on the door. She answered the door and was wearing little to no clothing. She had a fishnet, I guess you would call it like a mini skirt or a dress, just a one-piece item, but it was very, very see-through. She had nothing on the top. Basically, her breasts were bare other than the fishnet, and she was wearing a small pair of, I think, pink underwear.
Is this the same woman that you saw in the ads?
Yes, sir.
And then did you confirm with her that she was the person you were communicating
I
with?
did.
Tell us about your interaction with Ms. Johnson at that point.
I asked her if I could come in, and she stepped back and waved me into the room.
Is this a one-bedroom hotel room?
I believe it was, but I don't remember for sure. I don't.
Okay.
As I stepped into the room, I had my badge in my hand. I identified myself as a Salem Police officer, told her she was under arrest. The remainder of the arrest team had been standing just outside the door and followed me in. As we walked in, there was a set of closets off to the left, and then like a vanity off to my right, and then a single bed. And I was standing between the bed and the vanity when I heard another gentleman from inside the room say, "Hey, I'm in here," and I saw two hands come out of the closet.
All right. And so at this point, how many officers were there, do you recall?
Counting myself, I believe it was 4 of us.
All right. And so some of those officers were taking Miss Johnson out because of the arrest, taking her out of the room?
Actually, I wasn't. I was the one that had control of Miss Johnson. I wasn't able to get out of the room. I was essentially blocked in because the only way out was off to my left now, and that's where the closet was. And so I was blocked from exiting. I actually had to go the opposite direction to kind of get both of us out of any potential danger that there was.
You didn't know who this individual was that just put their hands out all of a sudden and said, "Hey, I'm here."
No.
All right. So tell us what happened next.
At that point, Mr. Johnson was found hiding in the closet and was removed at gunpoint because we had no idea if he was armed. We had no idea who he was. And then he was detained in handcuffs and was escorted towards the bathroom. I placed Miss Johnson in handcuffs, and she was escorted to the far end of the room and sat in a chair where I began to speak with her.
In speaking with Miss Johnson, were there? Did you gain access to any kind of electronics, phones, laptops, anything like that?
I did. I asked for and was granted written consent to search her phone and the room and her laptop on a consent to search card. This consent card I read to her verbatim, and she signed that card.
Did you check her phone at that time?
I did not.
You took it in as evidence.
Yes, sir, I did.
So tell us then about the dealings with Mr. Johnson.
Mr. Johnson was, as I said, walked into the bathroom where Detective Hernandez spoke with him. I really had very little interaction with him. Saw him briefly a few times as we were conducting the investigation. I did most of my talking with Miss Johnson, and then after that initial interview, I actually began to work on most of the paperwork and writing up the arrest documents and things like that.
Did you ever have any conversations with the defendant?
Very briefly, I believe. At one point, I think when I was talking with Detective Hernandez, at one point there was Mr. Johnson said he had money in his shorts. I think he was wearing like 2 pairs of shorts that we had to go in and get the money from with his consent to remove the money.
Did you remove that, or was it Officer Hernandez?
If I remember correctly, sir, give me just one moment. I believe that was me. That was me, sir. And it was later found out to be $1,200.
$1,200 in cash
Yes, sir.
that was found on the defendant,
Yes, sir.
Mr. Johnson.
Correct.
Do you see that defendant here today?
Yes, sir. I do.
Can you point him out, please?
He's sitting right there.
So 2 from my left, the council table.
Yes, sir.
And so that was the man that Mr. Hernandez, or Officer Hernandez, had taken into the bathroom and dealt with him at that point. You were still dealing with Miss Johnson.
That is correct, sir.
Did you later have an opportunity to? Well, let me ask you this: was there anything else that was found on the defendant that you were aware of?
I believe there was also a cell phone that I didn't find it personally. From what I was told, it was found in his hand. I believe at the time he was taken into custody. But
Officer Hernandez would have that information.
yes, sir.
All right. Were you aware then that did your investigation include, in addition to the prostitution situation, any drug activity?
Yes, sir.
Tell us about that.
I talked with Detective Hernandez at one point after he had been speaking with Mr. Johnson and learned that he had looked through with Mr. Johnson's consent his cellular phone. During those, or in doing that, there were text messages that were consistent with him attempting to sell oxys or oxycodone.
Is oxycodone a controlled substance?
Yes, sir, it is.
It's an illegal substance without a prescription?
Correct.
Is it legal, if, let's say you actually have a prescription yourself for those pills, is it legal for you to then sell those to other people?
No.
And so let's tell us a little bit more then about the oxy and then the text messages.
The Detective Hernandez told me that there were text messages on his cell phone that were consistent with him reaching out to individuals saying that he had 50 oxys, 5 milligram oxys to sell, and was going to sell them for X amount of dollars. Which, when he told me that, I had noticed in the room there was a bottle labeled or prescribed to Mr. Johnson of 5 milligram oxys, and there were 50 of them within the bottle.
So that physical description of what you found matched exactly with what the text messages said about selling 50 of the 5 milligrams.
Yes, sir.
All right, and talk about, if you can, Detective, the individual, or could you determine who he was talking with in regards to trying to sell these drugs?
A gentleman by the name of Nick was the one that was most commonly, most common messages that were sent. May I refer back to
Absolutely.
Thank you.
And while you're doing that, Detective, looking to find some of that, you did a whole scan and extraction of the cell phones, correct, to help you determine everything that's going back and forth between these people and who owned which phones?
Yes, sir. On Mr. Johnson's phone, so the text messages in reference just to the oxycodone portion of it dated back to the 5th of May to mostly to a gentleman by the name of Nick. Several messages to Nick back and forth. At one point, Mr. Johnson sent this Nick a text saying that his sister needs bill money, and that she would have to sell them all for $250. All 50 of them for $250. And the other gentleman was kind of haggling about the price, and that was the last messages were up till the 6th of May until the evening of May 15th, where a message was sent from Mr. Johnson's phone to Nick at about 7:44 p.m. Asking if he wants to buy some oxys, 5 mg, 50 of them for $200, which is actually a fairly good deal, since they're typically $1 a milligram. 50 of them would usually be $250, but to get 50 off, you could potentially make profit if you were going to sell them yourself. And so he sent that message to this Nick on the evening of May 15th. And then that was the last message regarding the oxycodone, or oxys.
Detective, I want to go back a little bit to text messages that were sent between Miss Johnson and the defendant in regards to the prostitution aspect of it. Does she go by the nickname of, or on the phone, Queen Moneymaker?
Yes, sir.
And were there verified messages sent between she and the defendant in regards to the meetup with you? I think one of them said, I hit a lick for $100.
Yes, sir. There was. I didn't look at the messages specifically in regards to me. There were literally thousands of messages, and when I wrote my report from that analysis, I took small snippets. I would still be typing if I was trying to get them all. A sample of these are from Queen Moneymaker, and the cell phone that's listed there is the same cell phone which I called from the back page ad on May 15th and May 16th.
To help verify that was Miss Johnson's cell phone. Then.
Yes, sir.
Okay.
They say things such as, I hit a lick for $100. A lick is a more common slang term for a robbery victim, but in this sense, it would appear that they're kind of using it for their own as like a John or a client in this sense.
Did you receive information and in talking with Ms. Johnson then and looking through her cell phone and seeing the messages she sent to the defendant, did you then question her about the defendant's knowledge of what she was doing in his role?
I did.
And what did she say?
She was very vague on a lot of those comments, but she would eventually kind of open up that he is there as a protection. They had a prearranged code signal or code word, such as when a client would get too rough with her, she would say no 3 times, and that was Mr. Johnson's cue to come out of wherever he was hiding, be in a closet or under the bed. And then Ms. Johnson denied that there was anything physical that happened between Mr. Johnson and a client, but said just through intimidation, verbal intimidation, he would make that person leave. That he's never had to hurt anyone physically, but it's usually the intimidation aspect that will get them to leave. They're freaked out when somebody comes out from under a bed or comes out of a closet and yells at them to get out. He drives her to local stores to buy debit cards, the prepaid debit cards, because they don't want to keep their cash on hand. And then they'll retain all their money that they've gotten from these profits in these little debit cards.
Detective, did she indicate whether that some of the proceeds from the prostitution would go to the defendant?
She did.
And was there an arrangement for that? How did she describe that?
Apologize. She said that the money was shared between them. She doesn't, quote unquote, pay her husband, but the money that they earned is shared between them, according to her.
And so, from speaking with Ms. Johnson, the understanding was that the defendant was there for protection, intimidation, and also get some of the proceeds from the prostitution that went on with his wife and other clients.
Correct. And she had no cash on hand. The only cash that we found was in Mr. Johnson's possession at the time.
Is it of significance that you found $1,200 on the defendant for your investigation?
Yes, sir, it is.
Why is that significant?
She had told me that the night before she had met with 2 other individuals for about the same rate as what we were going to be, our time together was going to be. And so, using that math, approximately $400 per person, that'd be about $800. She said she'd been with at least 2 people. So that's about right. There's $800 that she has admitted already came from prior prostitution activities. And then the additional 4 could have been another client or money that they may have brought with them from previous deals.
And that was all in the possession of this defendant, not Ms. Johnson.
That is correct.
Detective Smith, did you have any opportunity to, it's a collaboration, I guess, between you and the other detectives and other officers in regards to this investigation, correct?
Yes, sir.
So you share information with each other to help then further question, let's say, the defendant in regards to some of this information you received from Ms. Johnson.
Yes, sir.
You didn't have any conversations with the defendant particularly yourself, but Officer Hernandez did.
That's correct.
And the information you had obtained from Ms. Johnson, did you share that with Officer Hernandez so he could then question the defendant?
Yes, sir.
In your brief interactions with the defendant, can you describe his demeanor? Was there anything out of the ordinary? Was he acting weird or different, not coherent, anything of that nature?
Not that I remember. He seemed, from everything that I saw, he seemed to be answering questions fine. He seemed to be fine. I guess is the best way to put it. Nothing that stood out in my mind as there was something wrong.
You had, all of you had ended up collecting the cash, the drugs, the cell phones of both the defendant and Ms. Johnson, correct?
Correct.
And that's all been placed into evidence?
Correct, and the laptops.
And laptop. There were laptops there at the hotel as well?
2, yes.
Okay. And did those help confirm some of this ongoing prostitution business?
Yes.
The Shiloh Inn, that's here in Salem?
Yes, sir, it is.
It's off of Market Street?
Yes, sir.
That's in Marion County?
Yes, sir.
And that's where the defendant was located,
That is correct.
with all the cash and the drugs.
Yes, sir.
Was there an elementary or vocational school within 1,000 feet of that hotel?
Yes, sir. Room 319, which is on the south side of the Shiloh Inn, is within 1,000 feet of Hoover Elementary School. It's a school primarily attended by minors.
And what's the significance of that for your investigation?
With the text messages and the pills that were found, Mr. Johnson was charged with delivery of oxycodone. Being it was within 1,000, it was a delivery within 1,000 feet.
And help us to understand this delivery concept then. He didn't actually physically deliver anything on that particular day, May 16th, correct?
That's correct.
Is that called a constructive delivery?
Yes, sir.
And is that what you arrested him for?
Yes, sir.
And what's the constructive aspect of that? Can you describe that as your investigation and officer?
He made substantial steps in attempting to sell these. He wasn't. People weren't reaching out to him. He was actually reaching out to other individuals, offering the pills for sale at a reduced price, very specific, 5 milligram pills for this amount. It was not just kind of a random thing. And then, in addition, seeing the prior messages going back a considerable amount of time, it did not appear to be just a one-time random thing. That it was he was continually and actively seeking out someone to purchase these.
And it sounds like that particular last message you found that he sent to Nick was on May 15th, the day before, or that night, correct? May 15th in the evening?
Correct.
You don't know where the defendant physically was with that actual phone when he made that text, do you?
No, however, the laptops that you mentioned earlier, one of those was a black laptop. That laptop was identified as Mr. Johnson's. Through some technical stuff that I am not smart enough to understand, it was analyzed, and one of the things was, I think, recovered web pages. I'm able to open that up, and it shows me basically a picture of a web page that was recovered. However, our forensic guys do that, and it showed a back page ad in edit mode.
What does that mean to you?
When you go into Backpage, you can edit an ad or place an ad. And when you go into the edit mode, it allows you to download photos, remove photos from previous ads, kind of set up the ad the way that you want it to look. You can put in your verbiage in there, your phone number, whatever narrative that you want to add in your title. And when you're in the edit mode, whoever's doing that is the one that is actually placing the ad, that is typing it and doing what they want before it's placed onto the web page. And that was, if I remember correctly, that screenshot showed that the ad was being done at around 1,700 hours on May 15th.
So 5 p.m. on May 15th.
Correct.
That's the ad involving Jessica Johnson.
Yes, sir.
And that was on the defendant's laptop.
Yes, sir.
Did that help you then tie him more closely to the actually promoting the prostitution and being an active participant in promoting his wife as a prostitute?
Yes, sir, absolutely.
I think that's all I have at this time, Your Honor. Thank you.
Cross-exam.
Excuse me.
Thank you, Your Honor. Good afternoon, Detective Smith.
Good afternoon, ma'am.
Sorry, I'm fighting with allergies. You actually don't know, though, you don't have any information about who was operating or editing that back page ad on the laptop, do you?
No, ma'am, I don't.
Could have been anybody.
It could have.
Okay. There were no texts offering to sell the oxycodone on May 16th, were there?
On May 16th, no.
Okay. Did you participate in the actual arrest of Mr. Johnson? And by that I mean the physical transportation?
No, sir. Or, excuse me, ma'am. No, ma'am, I didn't.
That's right, I get that a lot.
I apologize.
No problem. Okay. So you don't know where he was transported after he left the motel?
He went to the jail.
He was transported to Salem Hospital, in fact, was
Oh,
he,
was
before
he?
going to the jail?
That I don't remember.
You just don't have personal knowledge?
No, I don't.
Okay. Are you the person who found the oxycodone?
I don't remember if I did find it. I can look on the
You want to take a
property
moment,
sheets.
love?
Absolutely. It was found in Miss Johnson's purse.
Okay, thank you. Nothing further.
Anything further,
No,
Counsel?
Your Honor.
Thank you. You may step down.
Thank you, Your Honor.
Would you like to remain or make you be released?
Remain, Your Honor.
Thank you. Return to the hallway.
Your Honor, this time the state would call Officer Erick Hernandez.
Okay.
May I have, Your Honor, may I have just a brief, just like a 2-minute recess?
2-minute recess, that's fine.
Okay, thank you, Mr. Johnson, if you can. Nothing that you know requires them to do that. You need to bring enough to convince a jury beyond a reasonable doubt.
All rise.
You're already at that point.
All right, thank you. Please be seated.
And I'd like to thank the court for allowing a brief recess.
It worked out just fine. My staff had some questions, so it worked out great. Call your next witness, please.
Thank you, Your Honor. The state calls Officer Erick Hernandez.
Under penalty of perjury, do you swear or affirm the information that you're about to give in this court and cause shall be the truth? Right. Have a seat, please. Once you're seated, state your entire name and spell your entire name.
My name is Erick Hernandez, and Erick Hernandez is spelled ERICKHERNANDEZ.
Okay, counsel.
Thank you, Your Honor. Mr. Hernandez, what do you do for a living?
I am a police officer with the City of Salem, currently assigned to the Street Crimes Unit as a detective.
And how long have you been in law enforcement?
I've been with the City of Salem as a police officer for just over 7 years.
And can you briefly describe your training experience in law enforcement?
Sure. Initially began my training as a police officer with the Basic Police Academy through the Department of Public Safety Standards training, with approximately 740 hours to complete that basic academy. After that, each officer goes through what's called field training, which lasts anywhere from 5 to 6 months, depending on the officer and how they progress through that training, which allows me to come in contact with the public. Actually allows me to have hands-on training in hands-on experience with different types of police investigations, everything from the basic standard traffic stop to assaults, sex assaults, drug investigations, thefts, the gambit basically of police work. Additionally, I've attended approximately 80 hours worth of drug-specific training with the Oregon Narcotics. ONEA, which is the Oregon Narcotics Enforcement Association. And ONEA basically provides narcotic-specific training, which is very specific to my role as a street crimes detective. I've also gone through the DEA Basic Academy, which has given me additional drug training through the DEA, which is approximately another 80 hours. Aside from that, a lot of my experience is basically hands-on through police work. So.
All right. Can you tell us then, did you assist in the investigation that took place on May 16th of 2014 involving Matthew Mayfield Johnson Jr.
I did.
Tell us about your role, please.
My role was basically basically to assist Detective Smith, who was the primary detective working that case. My involvement really didn't begin until the actual execution of the operation, where Detective Smith engaged in or set up basically what we would consider a sting, in which he made contact with Jessica Johnson, basically in answer to a Backpage ad, an internet website advertisement, and so that initial contact, I should say, basically occurred at the Shiloh Inn Suites located at 3304 Market Street, which is in Salem, Oregon, and in Marion County. So.
Right. And so, tell us, Detective, then, were you one of the officers that had entered that hotel room that day?
I was.
And tell us about your contact with the defendant.
So initially, Detective Smith approached the front door of the room, and after knocking, the door was answered by Miss Johnson. And if I remember correctly, she was wearing a pink fishnet dress and underwear. That was about it. There wasn't really much that she was wearing at that point. Detective Smith immediately identified himself as a police officer. Detective Dede and I were directly behind him, and we made entry into the room. After Detective Smith contacted Miss Johnson, Detective Dede began to check the remaining rooms that were in there, which was basically a bathroom and then a small closet. As Detective Dede was looking in the closet, he immediately yelled, "Show me your hands, show me your hands." And that was obviously a clear indication to me that there was somebody else in the room. Detective Dede drew his gun, and as did I. And as directed our point of fire to the closet, and Detective Dede ended up giving commands for Mr. Johnson to step out of the closet, which he did, and he complied. After that, he was ordered to the floor, and I took him into custody by placing him in handcuffs there on the floor in the middle of the room. So.
And do you see the defendant here today?
I do. He's seated before me.
And that's two from my left.
Yes, correct.
Can you tell us, Detective, you said you drew your weapon, so you had your weapon on you.
I did.
Were you in plain clothes or in uniform?
At that point, I was in plain clothes, but I was wearing a ballistic vest underneath, and I did have my badge. Generally, when we do these types of investigations, we approach the location in plain clothes with nothing visible, but as soon as we get to the point where we are actually going to identify ourselves as police, we'll make our badge visible either by a neck chain or just on our belt.
So was it visible on this particular occasion when you had contact with the defendant?
I believe it was.
And in telling the defendant, getting him down at gunpoint and handcuffing him, you said that you told him he was under arrest.
Correct.
And you signified you were a police officer?
I did.
And what did you do next with the defendant?
At that point, I separated him from Miss Johnson. I actually escorted him into the bathroom, which was just to the right of the entry door. So a small bathroom just in the room.
How long were you guys there, or what did you do?
At that point, I advised him of his Miranda rights first thing, and after doing that, I'd say I probably spent at minimum half an hour with him in the bathroom, if not longer. But I advised him of his Miranda rights right away, and then I basically began an interview with him.
Did he understand his Miranda rights?
He stated he understood his Miranda rights and that he had no questions regarding his rights.
Did you have him sign a Miranda rights card?
No, for the Miranda rights, he did not sign a card at that point because he was initially. That's basically one of the first things we do when we come in contact with someone. And since he was in handcuffs and he was hiding in a closet when we made initial contact with him, for our safety, I wasn't going to remove him from the handcuffs until I could establish whether or not he was an individual that was not going to be an officer safety concern and he was going to be cooperative. And since the Miranda begins so early in the contact, he did not sign the Miranda card itself. So.
And that's because he wasn't able to with his hands cuffed behind his back.
Correct, that's correct.
Your Honor, may I approach the witness?
You may.
I'm going to hand you what's been marked as State's Exhibit number 1. And can you identify that for us, please? I do have some scissors here, and I'll ask you to actually open that up, and we can pull out the contents as well.
Sure. Yeah, so this is the Miranda card here that I read to Mr. Johnson, and indicating the date as well as the time. My signature is on the bottom line, and there is no signature on that second line, but it does indicate handcuffed.
And is that typical that you would write handcuffed in on the signature line of the defendant if he was handcuffed and unable to sign?
That is very typical, yes.
And you said that he did verbally acknowledge his rights then.
He did.
You said you were with him for approximately a half hour in that bathroom.
Correct.
And after reading Miranda rights, you had questioned him and talked to him about a lot of the investigation, correct?
I did.
At any time during that conversation, did the defendant complain of pain or discomfort or anything like that?
No, actually, contrary to that, I remember asking him a series of questions, and I remember him actually, I distinctly remember him actually laughing at some of my questions as if they were comical and into how I was asking them. The only thing I do remember him asking, or basically complaining about, was thirst. He said he was thirsty at one point, which I provided him Gatorade, which he had some Gatorade there.
So no signs of discomfort or pain that you saw during that whole period of time?
No, discomfort and pain specifically, no. At one point during the interview, and it was very spontaneous and random, and I remember having to act quickly so that I could allow him to do so. But he was seated on the toilet in the bathroom, and just at one point, kind of randomly, he said, "I think I'm going to throw up." And so I allowed him to turn around, use the toilet, and he vomited in the toilet. So.
All right. During that time then in the bathroom, did he ever tell you that he was on any kind of medication that was, impairing his ability to understand you or communicate with you?
No, he didn't make reference to medication.
Did he make reference to any type of physical situation he was in, not talking about medicine particularly, but just saying, I'm really not feeling right, I'm not understanding you, or I really can't communicate very well with you?
After he vomited, he told me that he had, and I'm sorry, I don't remember what the condition was, but after he vomited, he told me that he had a specific condition and that this was common for him to vomit and not to be able to keep food down.
Okay. But nothing about understanding you or communicating with you?
No.
During your communication with the defendant, was there any time at all that you felt he was not understanding you or you were not understanding him?
No, not at all.
Okay. So let's go through then, after you had read him his Miranda rights, did you talk to him and interview him about why he was there and his contact with Miss Johnson and how he knew her?
I did.
Can you tell us about that, please?
Initially, I asked him what he and Miss Johnson were doing there at the location, and he indicated to me that they were on their honeymoon. I basically kind of asked him what role he was playing as being there, he initially told me that he didn't really know what I meant by what his role was. I asked him, after, like you said, basically explaining the investigation and why we were there, I asked him to tell me how he might be involved in Miss Johnson's prostitution activity. He kind of laughed at my questioning, and I remember specifically him saying, he said, "I see what you're doing. You're trying to get me to say I'm doing something." And I reiterated, basically told him I simply wanted him to be honest about what was going on at that point. And I asked him why exactly he was hiding in the closet. His response to me at that point was, quote, "All right, I'm going to be straight with you. I hoe too. We hoe together."
What did you take hoe to mean?
I asked him to clarify what he meant by he hoes too. Again, in clarifying this, and I apologize for the language, but he replied, and I quote, "I mean, I suck and I fuck with her." I asked him if he was specifically meaning that he engaged in sexual activity with Miss Johnson in exchange for money or other types of payments, and he said, "Yeah."
All right. Did you talk to him about, other than just the two of them in this agreement, were there others involved and what his role was?
Yes, so basically the way he explained how some of these arrangements would work, he said that if somebody wanted to, engage in sexual activity with Miss Johnson, that he would be a part of that deal, but they would not know that he was a part of that deal until they actually reached the location. And I asked him if he meant to tell me that if someone agreed upon those sexual services, that he just included him in the service without telling them prior, and he said yes. He again reiterated that he did not, or that the person coming to meet with Miss Johnson never actually knew that until they got there.
Never knew that he was going to be there.
Never knew that he was going to be part of that until they actually got there. And he said when they show up is when he explains. And I asked him how that usually goes over with the person that shows up expecting to meet with a young lady and then realizing that he was there as well. He said, we are all consenting adults and it's just casual fun. That was his explanation and reasoning behind that. I asked him if anyone actually agreed to this once arriving at the location and knowing that Mr. Johnson was going to include himself in the activities. He said yes, and if they don't feel like they are going to include themselves, that they would just sometimes watch. That would be part of the agreement at that point. And the only other portion he had as far as the agreements, if for some reason he said that they didn't want to include themselves, that they would just leave. That was the only other caveat to his explanation of how the activities would work.
Detective, did you notice that there was a phone that the defendant had at this time?
Yes, he was in possession of a cell phone.
And where was it?
If I remember correctly, he had it in the pocket.
And did you talk to him about his phone, whether you could look at it?
I did.
Tell us about that.
So I asked him if I could look through his cell phone, and his response was, "Go ahead, you can look through whatever you want." So at that point, I read Mr. Johnson the department-issued consent to search card, which actually has verbiage allowing us or asking for his consent to search. And if I may clarify too, this is actually the second time that I had read specifically that card to him. Prior to initiating my entire interview with him, other detectives were already were preparing to search the room, and since the room was shared between him and Miss Johnson, I read it to him the first time while he was still handcuffed. Read it to him the first time, and he agreed to allow us to search the room and the possessions that were there. So this was actually the second time that I had read the consent to search card to him. So he agreed to the consent search. I actually, at this point, removed him from handcuffs so that he could sign the consent to search card.
And why now, at this juncture, were you willing to remove the handcuffs for the phone, but not initially after the first Miranda rights were read?
Right. I had spent significant time with him talking about what was going on, talking about the investigation. I could tell that he was being what I would consider cooperative. He wasn't being violent. He wasn't being offensive. He was talking to me in a calm demeanor. So at that point, I considered him not necessarily to be a threat, so I felt safe at that point for my safety to remove him from handcuffs so that to allow him to sign the consent to search card.
So that at that juncture, your officer safety concerns were relieved.
Right.
All right. You did have him sign that as well?
I did.
Is that part of Exhibit 1 that I handed you?
Yes, it is.
And can you describe for us then on that card, did he sign that and did you sign that?
I did. So he signed it. Well, you can see on the first line where his signature would be. The initial portion of it says yes, which I wrote, and that would have been for the first time that I read the consent to search card. And then right next to it is his signature, and then my name is listed at the bottom with date and time at the bottom as well. So,
Your Honor, at this time I would offer State's Exhibit 1.
And Your Honor, because that envelope was sealed, I didn't have a chance to look
Sorry.
at all the cards. If
Yes,
I might,
please.
Yeah, let me.
is this all of them?
I'm sorry, there is a second one here for Miss Johnson.
This one says room and car. Is there one for the phone? That one says room and car. See it? Right there.
Room and car. So yes, thank you. This is just to clarify too, on this particular one that the defendant had signed, it says room and car here.
Correct. So that would have been for the first reading of the consent to search where I wrote yes. The second portion would have been for the cell phone. And obviously you can see there's limited space, but I did fail to write cell phone beside his name or in any open area, I guess, of that card.
This top portion says all property within the premises that you're allowed to search. That's what he's consenting to.
That's correct.
And you specifically asked about the cell phone.
Right, the second time, yes, and that's when he signed.
So the first time is kind of when he was in handcuffs and you just wrote room and car where he verbally had said, yes, you can search all of this.
That's correct, yeah.
And then when he finally said yes, quote, yes, and he recited his name, that was for his cell phone.
Well, I wrote yes after the initial reading for the room and card because he was unable to sign, and then during the second portion, when I read it the second time, that's when I removed it from handcuffs, and he was able to write or to sign the card himself. But I didn't write specifically cell phone or anything on any of the free space that's might
Just
be remaining.
all inclusive.
Correct. Yes.
And so, Detective, so that
Yes.
I'm sure I'm clear, you use the same card twice.
Yes.
That's what you're saying?
Yes.
Okay.
That's correct.
No objection to State's Exhibit 1.
States one submitted. Can I see that, please? Further questions?
Thank you, Your Honor. So Detective Johnson, Detective Hernandez, did you ask Mr. Johnson then if he could provide you the passcode to actually access his phone?
Yes, I did. I noticed immediately when I began to handle the phone that it was password protected. So I asked him if he would provide me that passcode so that I could actually review the contents of the cell phone. And he did. He verbally provided me the code 0550 to access.
Did you punch that in?
I did.
Did it access his phone?
Yes, it did.
And again, you only knew that from the defendant telling you what it was, correct?
That's correct.
So were you able to then look at text messages on that phone?
I was. I reviewed several messages. One contact in particular reviewed messages from a contact listed as Moneymaker. After looking through the contact listing, I saw an associated photo with that contact, as many cell phones will allow you to do now, and I recognized the photo of the person to be Miss Johnson.
The same Miss Johnson that Detective Smith had made these arrangements with.
Yes, that's correct. During the text message conversations that I reviewed between Mr. Johnson and Miss Johnson, Miss Johnson made reference, several references to having quote a lick, and in my experience and training experience based on human trafficking and prostitution type investigations, I know that term is common for referring to a John or a male subject just engaging in the soliciting prostitution. So somebody that the person is planning on meeting with. So.
And on the defendant's cell phone, was he listed as quote P, the letter P?
I did read several text messages where he had actually referenced himself as P, just the letter P. Again, just kind of based on training experience in these types of investigations, I know the letter P to be short or a way basically to commonly refer to someone's self as a pimp. And I specifically asked Mr. Johnson why he was referring to himself as P in his text messages.
And what did he respond?
His reply was, all right, I'm going to be straight with you. I portray myself to be a pimp, but it's just something I've done because of how I grew up and how I live my life. I asked him what exactly or how exactly he portrays himself to be a pimp, and he just said, like on Facebook and stuff, I just do it because that's what people expect of me.
In reviewing more of those text messages that were on the defendant's phone, did you come across any indications of drug activity?
I did. I came across another text message conversation where I found an outgoing text message where he told the recipient of that message that he had 50 oxy pills for sale for $200. And later, after talking to Detective Smith, I learned that there was actually a prescription bottle in the room that contained 50 oxy pills.
All right. Based upon that contact with the defendant, then, did you arrest him and charge him with the prostitution, compelling in the delivery of the oxycodone?
Yes, I did.
This was all within Marion County?
Yes.
And we understand from Detective Smith this was also within 1,000 feet of a elementary or vocational school in Marion.
That's correct.
Lastly, Detective Hernandez, when you arrested him and took him in, did you end up taking him to the hospital?
I specifically did not transport him anywhere. Because of our location and kind of how our team sets up these operations, we're generally not able to conduct transports, so a patrol officer will respond to the location and conduct our transports for us.
And is that because you're typically in plain clothes and unmarked vehicles?
Correct.
So you want him transported by an actual marked vehicle with an officer in uniform?
Right, correct.
All right. And again, anything unusual about the contact you had with the defendant where he wasn't understanding you or any of the questions or things you found?
No, at no point do I feel like he couldn't understand me or like he didn't. It was very clear that he understood what I was saying, and I understood him perfectly well. So.
Thank you. Nothing further.
1 minute. He talks faster than I type. Okay, Ms. Ryder.
Thank you. Good afternoon, Detective Hernandez. You have no idea where Mr. Johnson was, or if it was Mr. Johnson that sent the text messages from his phone, do you?
No, obviously I did not watch the actual message be sent.
Okay, all right. And with regard, do you know that he was in fact transported to the hospital on the way to the jail?
I was informed of this later.
Okay, but you didn't do the transport?
No, I did not.
That it's somewhat unusual for a person to be transported to the hospital before being taken to the jail, isn't it?
I think more so nowadays it's becoming much more usual because of not because of the person's condition, but because of the jail policies.
Okay, but if there's any concern at all about a person's physical condition, they need to be checked at the hospital.
Correct. Yeah, it could be depending on use of force. Like specifically, if we use a taser, that person needs to be checked by a medical professional. Not that it's
Sure.
life-threatening or that their physical condition is that they're unable to do anything or they may be just fine, but it's just because of that policy they are required to be evaluated first. So.
But in this case, when he was brought out of the closet, to use that turn of phrase, you wouldn't say it was excessive force, would you?
Oh no, definitely not.
And in fact, although guns were drawn, and I guess this is obvious from your testimony, but nobody shot at him.
That's
right?
correct.
Okay, and nobody used their taser.
Correct.
Okay. He did throw up when you were talking to him?
He did, yes. Yeah, I specifically remember him saying that was a common thing for his condition.
Thank you, nothing further.
Redirect.
Nothing further, Your Honor.
Right, thank you. You may step down. Should he remain or was he released?
Remain, Your Honor.
Thank you.
Your Honor, this time the state has nothing further.
So what I have in front of me are the following. Motion to suppress the search of defendant's cell phone on the grounds that evidence was illegally obtained. The cell phone was outside the scope of consent. Also, I have before me a motion to dismiss for lack of proper venue, that the charge is based on events alleged to have occurred on May 16th, and that the alleged crime, if it happened, did not happen on the 16th of May. And then finally, that the defendant moves for an order excluding all statements made by the defendant after his arrest on the grounds he did not give a knowing and intelligent waiver of his rights pursuant to Miranda. Those are the issues the court has before it. Any other issues that the state believes remains before the court?
No, Your Honor.
Ms. Ryder, do you wish to put on evidence?
We do not, Your Honor. And one clarification of the court's recitation of the motions before the court.
Thank you.
I believe that the motion to dismiss for lack of proper venue speaks only to count 2, the delivery of oxycodone within 1,000 feet of the school.
Argument from the state.
Thank you, Your Honor. Starting with the search of the cell phone, Your Honor, clearly the officers were there lawfully based on their investigation. They had entered the room, found the defendant's wife, who was clearly prostituting herself. The defendant was there. He came out of the closet. I guess, as you said, his hands came out first and said, "Hey, I'm here." They brought him out at gunpoint, took him in custody for officer safety concerns. I think the main issue here is whether the defendant voluntarily consented to the search. And you just heard from Officer Hernandez about that contact, about the search. He verbally read him his Miranda rights. The defendant acknowledged those rights. He did not sign the card because he was handcuffed. The detective informed the court that based on officer safety concerns at that particular juncture, it's very normal for them to keep them handcuffed, and they will write handcuffed on the line of the signature of the defendant, and then the officer signed that. After the Miranda rights were given, then the defendant made several statements, including the consent to his search of his cell phone. In regards to that particular card, as you can see, it says room and car, and I had the officer clarify that was the first verbal consent that the defendant gave to the search of the entire room and its contents and the car. Here then, when the defendant was allowed to be unhandcuffed because the officer safety concerns were alleviated, then the defendant signed that card saying, "I still consent to all of this." And I asked the detective specifically, was that in relation to his cell phone as well? He said yes. The defendant signed that. I think what also goes to corroborate the fact that the defendant was willing to consent to the search was that he verbally gave the officer the code, the only way to get into the phone, which was the 0550 code, and then the defendant willfully gave that over to the detective to finish searching the cell phone. All the contents that are on the cell phone, of course, at that point would be admissible evidence showing the relevance to the different text messages in regards to Queen Moneymaker, which is his wife, we learned through Detective Smith, the transactions that were taking place, the fact that she was getting ready to do a lick, and then, of course, the drug records. So I asked the court to deny the motion to suppress in regards to the search of the cell phone. Moving to the defendant's statement, since we're already talking about the Miranda rights that were read to the defendant, I asked the court to say that that was a willful and voluntary waiver on his part, and that he did agree to talk to the officer. You heard from Detective Hernandez many different quotes, and he specifically quoted those in his report of statements the defendant was making in regards to the actual contact that he was having, his role in that, and then saying, "All right, I'm going to be straight with you. I portray myself to be a pimp, but it's just something that I've done because of how I grew up and how I live my life. I just do it because that's what people expect from me." Again, that's an indicator that goes towards the promoting prostitution, his statements about what his role is, the fact that he's hiding in there. The reason I elicited his wife's statements was effect on listeners. She's not here for this motion, didn't need her to be. It really was the effect on the officers in their investigation that showed why Detective Hernandez started asking the defendant about his comments and his role in this situation. He clarified, yes, we do this together, I'm there for her protection, etc. This is his own statements again, Your Honor. There was nothing indicating that he did not understand the questions, that it was not voluntary. I asked the detective, was he complaining of pain or discomfort or not understanding you in any way, shape, or form? He said no. The only time was when at some point he said, "I'm going to be sick," and he threw up. But again, even after that, there was no talk about, "I really don't understand what you're doing. What's going on here? I'm not voluntarily consenting to any of this." Nothing of that nature occurred, Your Honor. In fact, the detective said that sometimes the defendant was actually laughing at some of his questions. So I think that also shows the voluntariness and the defendant's knowing waiver here. Your Honor, I was not privy to the doctor's testimony of the day. I did speak with Mr. Tingley, who presented that portion of the case. My understanding from what the doctor had testified to from the defense was that yes, he can be on certain medications, and yes, it can cause him some sort of maybe pain or something like that, but nothing about voluntariness of statements or not knowing that it could be a diabetic situation. But again, the defendant never mentioned that. He just said, it's common for whatever I have here that I get sick and throw up. Again, I don't think there was any correlation from what I heard understand the doctor's testimony to be to the defendant not voluntarily waiving his rights here. So I'd ask the court to deny that motion to suppress his statements. Lastly, on venue, Your Honor, I think the court's aware of the new case law that came out in regards to State v. Mills that talked about venue is you can't argue venue in the middle of trial. It's not something the state needs to actually prove venue, but they can raise it pre-trial, and that's what's been done here. As Ms. Ryder indicated, the only issue of venue is to count 2. So let's look at the count 2, Your Honor, which is the delivery of oxycodone, or Oxycontin. This is an actual constructive delivery, and that's why I had the officer explain, well, what are you looking at? And it's a substantial step or an attempt to sell the drugs. That's delivery of a controlled substance by constructive delivery. Here, the fact that he had $1,200 in cash on him, which not only goes to helping prove the prostitution, but it also goes to showing the sale of drugs. He also has the oxy on him. It's not actually on him, excuse me. It was found in his wife's purse, is what I believe the testimony was. But again, it's his prescription. So yes, he lawfully has that, but he's not entitled to then try to sell that. That's what he was doing in these phone messages dating back, I think, from March up until the last one, which is the evening of May 15th of this last year, to this person called Nick. And then he's saying, I'll sell you these. I got 50 pills. Well, weird. It happens to be 50 actual pills that are still left in the bottle. They're 5 milligram tablets, exactly the same. And on or about, Your Honor, it doesn't have to be a specific date. The court knows that that's not a material element that we have to prove. So in any situation, again, where a defendant may have sent that physical text message at some other location or at a day or two before or a day or two after is irrelevant. The fact is that he's constructively delivering it when he's in possession of the phone. There's indicia of delivery on the cell phone, and he has the drugs with him at the time, and he has cash with him at the time. So the fact that he's at that juncture within 1,000 feet of a school, in that hotel room, it's the venue issue. Really, we have venue when any material element can be proved, and any element it may exist within this county. Well, he's possessing these drugs. He has the phone records with him, or drug transaction records, if you want to say that, on his phone, with cash and with the drugs. So I'd ask the court to deny that motion to dismiss for lack of venue. Thank you.
Okay. Ms. Ryder.
Thank you, Your Honor. I will address the motion with regard to venue. The only evidence that we have of the attempt to sell the drugs is the May 15th. That would be most recent to the May 16th incident. And there is absolutely no record evidence of where Mr. Johnson may have been when he sent the May 15th text. I would suggest to the court that there is insufficient evidence for venue to lie in Marion County on that count.
Can I ask you a question?
Certainly.
Okay. So it's not always a circumstance that the court hypothetically agrees with, but isn't it the case that if I have a prescription for X and it's filled, and I then give my prescription, my bottle of X to Sam, haven't I delivered a controlled substance? And so in this situation, because it's in his wife's purse, not his possession, her possession, isn't that evidence of delivery within 1,000 feet?
I think you'd have to know more about the circumstances of that, because that means that every time in Fred Meyer, if I may, that I get a prescription filled and I've got 2 cantaloupes in my arms and I say, here, honey, hold this, and I hand him the prescription, I've delivered a controlled substance to my husband. So I think that's a little bit overbroad.
Okay, fair enough.
Application.
Fair enough.
Okay. In this case, the money that Mr. Johnson has is not evidence of drug delivery. If there was an attempted delivery, which is what the text messages are more indicia of, then we have no idea where that attempted delivery took place. In fact, there's not a constructive delivery kind of situation here in Marion County. We've got an attempted delivery perhaps, but it's an attempted delivery somewhere else, because the 50 oxycodone are still in Mr. Johnson's constructive possession, with them being in his wife's purse. That's what we would argue. and we have no idea where that text was sent. With regard to the other two motions, the motion to suppress regarding his statements and the motion to suppress with regard to the search of the cell phone, those are inextricably tied to his physical condition, because if he cannot consent to give statements voluntarily, then he cannot consent to a search of the cell phone voluntarily as well. And as this court heard from Dr. Harbison, the metformin that Mr. Johnson was given did cause him nausea and perhaps some disorientation. Dr. Harbison testified that there were adverse effects to that prescription being given to Mr. Johnson when in fact he was not diabetic, and that prescription could interfere with his ability to cooperate and with his ability to make rational decisions. We would suggest to the court that his vomiting in mid-interview was indicia of exactly the kind of symptoms that Dr. Harbison is talking about, and we would ask the court to suppress both the statements that he made as not voluntary based on his physical condition and the search of the cell phone based on his physical condition.
Counsel.
Thank you, Your Honor.
And I'm looking here, did you file a brief in this case?
No, Your Honor, it's
Okay,
just going to be testimony from the
Okay.
detectives. Your Honor, I think I understand Ms. Ryder's argument, the defense argument, but when we talk about this is on or about, so the text message from the night before is on or about May 16th. That's not an issue. So I think what I think the legislature's intent and the court's intent really is that if you're going to say we don't know where you were physically within this state when you sent that text message, then no county can prosecute the defendant for that. That's why we get to look at then the other indicia of the activity of that drug stuff going on. The night before, he has a cell phone with him at this time. He has stopped, he has cash, he has the drugs with him. I do agree with the court's analysis that it is, I guess, a technical delivery when he gives it to his wife, and his wife is the one that has the drugs in her purse. But when you look at the totality of the circumstances, this is a little different from when you just pick a prescription for a family member and take it home to them. Here, we have no evidence that was testified to by anyone saying why the defendant's drugs were in Miss Johnson's purse. The other fact is, why is all the cash then not in that purse, and why is it on the defendant? So again, another indicia of what his activity is in both the prostitution and the drug activity. And like I said, I think if you say on or about this date, yeah, we don't have to prove a specific date. I think it's close enough that we have a text message from the night before, and that he's actually there on this
The
date.
text message from the night before says,
I got 50 pills, I'm trying to sell them for $200 to this guy named Nick. And then, of course, then we have the pills with the defendant in the hotel room that corroborate him trying to sell these drugs. It's an attempt. It's absolute constructive delivery.
and the contact with the officer the first time, when the officer basically blew her off and then came back to talk to her again. His testimony was that occurred on what day? Was it the day before?
That was May 15th, yes,
The day before.
the day before. And then he recontacted her May 16th, and they set up that 1 o'clock in the afternoon meeting at the Shiloh Inn.
And so at least there was evidence, arguably, that she was in Salem on
Yes,
the 15th.
and she indicated as such in that ad that she had placed, and was going to meet with Officer or Detective Smith. The only other thing, Your Honor, I would also say about the doctor's testimony is, my understanding is the doctor said this could have these effects, but he has no idea whether it had these effects on the defendant at all, and we never heard that it had any effects on the defendant. He doesn't, of course, have to testify, but there is no evidence before this court right now indicating that he was having trouble communicating because he was suffering from these adverse effects that could be there. We just don't know that, and I'd ask you to listen to the detective's testimony about his demeanor, his conversation with him over a half an hour, and again, no complaints of, I'm not knowing what's happening here, what's going on, I'm feeling these effects.
Well, I think you've heard my basic thoughts. As to the motion to suppress defendant's statements, the defendant's motion is denied. As to the defendant's motion to suppress evidence, the defendant's motion is denied. And as to the motion to dismiss for lack of proper venue, I think there's circumstantial evidence from which one could decide that the venue is proper. And so in this case, the court believes that there is evidence that the venue is proper, and so the motion to dismiss for lack of proper venue is denied. Anything further from the state?
Just that, Your Honor, the state will prepare those proposed orders. I'll submit those to Ms. Ryder for her and the defendant's review, and then submit those to the court. And I think the next date that we have set is a pretrial on July 6th.
With a trial
July 14th and 15th.
during open water. Okay. Ms. Ryder, anything further from the defense?
My concern, Your Honor, is that with regard to the motions to suppress the statements and suppress the search of the phone, I think the court needs to articulate a basis for the denials of both on the record.
I can
For
do
the record.
For the record, I can do that. I'm usually more eloquent in writing than I am in off the cuff. I know that some judges believe that off the cuff is great. I'm not the best off the cuff person, so I will write you a probably brief opinion letter that tells you, ding, 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 these are my reasons, and I certainly can do that for all of the motions if you would like.
Thank you. I just think it's required for the record. Thank you
Okay.
very much.
Thank you.
And Your Honor, then I will wait for that opinion letter. That way I can incorporate that within the orders that I present.
That would be fun. All right, so we will do that. I will tell you that I have been absolutely swamped for the last few days, and I'm not sure that that will give way in the next last few days and in the next few days. But I will tell you that it will go toward the top of the pile of things that I have awaiting me, and I will try to get it to you as soon as possible. We have a free trial on what day?
July 6th, Your Honor?
Next Monday.
I'll have it to you on or before July 6th, so
That's fine.
you may get it on the 6th, but I'll try and get it to you on or before then so that the state can get an order and we can move forward from there. All right, we're in recess. I appreciate everybody's time.
Thank you, Your Honor.
Thank you, Your Honor.
We ain't in recess. I'm taking you back into time. Now you see where the officer's testimony is about to crumble. And like I said, I'm going to prove to you that Douglas Hanson was never in court when my doctor came. He did that on purpose because he already knew that Susan Tripp, the fact-finding judge, was going to allow him to get away with David Kuhn's motions being dismissed. First of all, Gail Ryder wasn't the original attorney that filed those motions for me. David Brian Kuhn was the and I want to show you guys those motions that she denied because I think it's only fair. Susan Tripp really, she needs to be held accountable too. The more and more I try to forgive her, the more and more I find out just the wickedness in what she did to me. When we talk about what she did was foul, she straight up legitimately did me in. And I got these motions just ready. And it states, before we get into Dr. Harbinson, we want to look at these motions and briefly show you what motions that she dismissed. If you was paying attention to my video earlier, I was talking about the verified correct copy of original dates to the Marion County courts. It's quite obvious that Douglas Hanson really don't know what he's doing, because he can't control everything. He can't. You know, these motions were very good from David Kuhn, but they took Kuhn off my case and they gave me Gail Ryder. They stuck me with Gail Ryder. You know, motion to suppress defendant's statements. And what we're gonna do is actually I'm gonna let you guys hear from Dr. Harbinson. Dr. Harbinson was a very, very, very good doctor. This man saved my life. He not only knew that I was suffering and I didn't know what was wrong with me at the time, because I'm thinking, since my grandmother is a diabetic, my mom and my dad is diabetics, I gotta be a diabetic. So I'm believing in my doctor, you know, and this is why people have a fear with going to the doctor, because sometimes the doctor can misdiagnose you and really harm you in your life later on in life when you get older, you know. And when I was taking this pill, I thought that, you know, I was being cured. You know, I thought, you know, my diabetes. I thought I had diabetes basically. So that was a malpractice for real. Because if I would have took the insulin shot, then I could have potentially been dead. So you heard these officers and Douglas Hanson. If you reading into the comments, you see that I say Douglas Hanson is leading the officers, leading the witnesses. You're lying, and you wasn't even man enough to go question the doctor. You didn't want to question Dr. Harbison because you knew Dr. Harbison was going to tell you the truth. And not only that, what Douglas Hanson is hiding from the public is the fact that my doctor, Andrew Ross Harbison, and nothing that all these pictures that I got is public. I'm not discriminating on them. I'm just using them to show the public the people that I'm talking about. Douglas Hanson claimed that he prosecuted me legally. Then how the hell do I got all this information, and why are you choosing to cover it up for your own personal gain? You working for the city of Salem just to keep tabs on my family, and you playing trickery games with my wife's background and all that, and enough is enough. So we gonna get into Andrew Ross Harbison's testimony, and we're gonna see why Douglas Hanson kept reminding the officers that Matthew Mayfield Johnson Jr. wasn't sick at the time of the arrest.
Present, I'm impressed with this attorney, Ms. Gail.
Right. This is time set for appearance. The state wishes to call the case.
Yes, Your Honor, we're here today for State versus Matthew Mayfield Johnson Jr., 14C 42686. Defendant is present. I'm impressed with this attorney, Ms. Gail Ryder. I'm Tobias Tingley, representing the state. We're here today for a motion to suppress due to some calendaring issues. As sick attorney, so you're in day 3 of a trial, Your Honor. We're, sounds like, unable to hear the full hearing today. We will be hearing from a defense witness, a doctor in the case, and then setting over the remainder of testimony for 6:30. That's June 30th at 2:30, or excuse me, 2 p.m. Your Honor.
All right, thank you. Mr. Johnson,
Yes, ma'am.
go ahead and stand up. Good morning. So, Mr. Johnson, unfortunately, judges' cases sometimes have a life of their own. I thought this case that I'm trying now would be done yesterday, early afternoon. Yeah, that didn't happen. And so I've got a jury coming in at 10 o'clock. And so really we can't do the motions, okay? And I apologize for
That's
that.
okay.
Okay. There is a doctor coming, however, from far away. And I told Ms. Ryder that I'd go ahead and listen to the doctor because we don't want to inconvenience him more than we need to. But the other issue we need to take up is, all right, thank you. Mr. Johnson, if you'd stand back up. I'm sorry I have to have. So here's the question. In a request for new counsel, I need to put you under oath, and you need to explain to me why, in detail, you don't want her to represent you. So if you raise your right hand, other right hand, there you go.
Sorry.
Under penalty of perjury, do you swear or affirm the information you're about to give in this court and cause shall be the truth?
Yes, ma'am.
All right, go ahead and have a seat. Now, by my record, you've had a number of attorneys appointed by the court.
Yes.
Do you remember how many?
I have 4 of them and 2 substitutes.
You've had 4 attorneys and 2 substitutions by the court.
Yes, ma'am.
What about the other 2?
I know. The first man, he was the arraignment, and Carrie Weiland mentioned that it was their practice to have him step in. So I didn't count him as a public defender. But the remaining on the 27th of May, which was set for a preliminary hearing that I never got because Carrie Weiland District Attorney Douglas Hanson never showed to it, and have a judge on audio transcript actually setting that court date, and they missed it, and Carrie Weiland sent in Michael Lee Griffith in her replace. She replaced him and didn't show up, even though she knew she was my attorney at the time, and that I had a preliminary hearing set, and I was wondering why I was stripped from that when a judge Senate said, preliminary hearing set for May 27th, and an indictment if one should be issued. And the conflict of interest with the public defenders started to occur is because I never waived my preliminary hearing rights away. And I found out through my audios that Carrie and Douglas Hanson had waived my preliminary hearings away through email. Off court record, something I never knew about because I never talked to Carrie Weiland ever in my life.
But you were subsequently indicted.
Yes.
Okay. And you had the public defender at that point.
I didn't get an indictment until October.
Okay. So once you got the indictment, who was your lawyer then?
Jessica Kempy.
Okay, Ms. Campy. And did there come a time when you became did not like Ms. Campy's representation?
To be completely honest with you, Your Honor, I only met her one time, and I had emailed her expressing why my preliminary hearing was stripped from me, why nobody came. So she actually investigated it, and she said Carrie Weiland wrote in her notes that she made a visit to me, and then I went as far as to go down to the Marion County Court annex, and I asked to get a printout of her visitation log, and come to find out she never made any professional visits to me. And what happened was she did make a visit June 1st, which was after it was, I can remember very vacantly that it was like real late. I was laying in the bed in my cell, and they opened it up and said I had an attorney visit, and it was finally Carrie Weiland, who I never even met, but previously she already had waived away all my rights.
So did you ask that she be that someone else be substituted in?
Actually, she wrote, because I had wrote a complaint on her misconduct to the state bar, and we were going through this for about half of a year, 6 months, and she wrote in her report that she wasn't able to, or she quit the job as public defender. She took up a job down in Benton County for assistant district attorney. And then that's when Jessica Kemphy replaced her.
Okay, but Ms. Camphy is the one that you filed a bar complaint against?
No, I found the complaint against Carrie A. Whiteman, Your Honor.
Okay. All right, so then Ms. Camphy filed a motion to withdraw because there was a conflict between you and her.
Right.
Okay. And so then what happens? I appointed Mr. David Coons.
Yes.
Okay. And then Mr. Coons was your lawyer, court appointed, and you then asked, after you had Mr. Coons, you asked for a different lawyer.
See, that's where they're confusing you at, Your Honor. I never ever asked for a public defender. I stressed the issue of why didn't the district attorney take this evidence that he supposedly had to a preliminary hearing and actually get an indictment, you know, and that's been my argument up until this day, because it's my constitutional right to a fast and speedy trial.
Can we move past the preliminary hearing?
Yes,
Okay. So you had Mr. Coons,
yes,
and he filed an affidavit that said the attorney-client relationship has deteriorated to an unaccepted level, and that he was also ethically required to withdraw, just like Ms. Campbell. So do you feel like that was accurate, that you guys really didn't get along?
I talked to him twice in actual meetings. Most of it came through mental, and that was through emails. I've created several different folders and keeping up with these people. And
Can we just ask you this? Did you want Mr. Coons to stay as your lawyer?
he was actually a good attorney. What I found out is that his disciplinary action through the state bar, because I was a little bit worried about him, and they want me to explain to them what happened May 16th, but they never let me explain it, or they never ever let me.
So you turned Mr. Coons into the bar?
No, I didn't turn him into the bar.
You said something about they wanted you to explain about May 16th. We're talking about Mr. Coons.
Yes,
Who wanted you to explain?
Mr. Kuhn wanted me to explain to him why I went to the bar on my concerns about him, because I had done some investigation on him, and I told him,
You went to the bar to talk about Mr. Coons.
Yes.
Okay.
Yes, ma'am.
Okay. So then I appointed Ms. Ryder to represent you.
Yes.
Okay. And what are your concerns about Ms. Ryder's representation of you?
From when Mr. Kuhn withdrawed off my case and passed it off to Miss Ryder, I don't know what transpired between them two, but she instantly had this attitude towards me, which made me feel like she wasn't there to listen to me. I try to exercise my right as far as bringing some type of support with me, because of I've been through so many different attorneys, and I was having trust issues. So I was like, I talked to my doctor, and he advised me to bring along somebody that could help me, because of my stress and my anxiety problems and stuff. It's real bad. So I took my support with me, and she immediately kicked them out. Like, she kicked them out, didn't let me explain nothing. She kept on saying how much of a concrete case this was, and never once have I been able to introduce any of my evidence that I got from Carrie Weiland. In the first discovery that I got was some audio CDs, which proven that I gave officers only to search my vehicle, and I was trying to show her the proof so I could build a stronger and better defense. But I don't have no say. You know, I only talk to her through emails, and this is what I do every day, is try to read and understand her, because there's no, I can't meet her. She canceled my visits at the state bar, claiming that she needed more time to file motions that Coon filed for me in February 5th.
Sir, who are you? Sir, who are you?
Just a friend of Matthew's. I just been reading some of his stuff. I've been helping him out through this. I can leave if you want me. I've listened to him. My name's John. John. I just want to
Have you written emails to Ms. Ryder?
that's not
Okay, all right, you can remain.
this is John.
All right. So, you write back and forth in emails, is that correct?
Yes, ma'am.
How many emails have you written back and forth?
This whole binder right here, I would say over about 100 emails.
Between you and Ms. Ryder?
Yes. And not only that, Your Honor, the day that the district attorney read off that plea, I was kind of confused because they had sent me a different plea offer. That wasn't even a plea bargain that was explained to me properly, because for a long time I was given a different plea offer, and not only that, the district attorney sent her the same exact plea, but when she came in here, she explained another plea offer to you. And moments after that, after court that day, she then wrote me an email explaining to me how she can get certain charges to go away and stuff like that. And it's like, she know that I don't want to take a plea offer, so why
All
would...
right, so let me tell you where we are right now. This is the lawyer you will have, or you can represent yourself. Those are your two options. You have a right to a court-appointed lawyer, but you don't have the right to any court-appointed lawyer. You have the right to a court-appointed lawyer. And in this circumstance, we've provided a number of opportunities for you to have a court-appointed lawyer. It is not unusual for a lawyer and their client to see things differently. That's not unusual. It's not uncommon. It's also not unusual or uncommon that a lawyer will say, this is a good argument, this is a bad argument. You can make progress with arguing this, you are never going to make progress on arguing this. Or you don't have a very strong case, which is potentially not in your best interest to take it to trial, or you have a good case. And I know it's an imposition to go to trial, but you should. I don't know what has been said. Here's the circumstance. If you wish to represent yourself, that is a serious decision. I had you think about that the last time I talked to you, and ask that you think hard about that decision. You're not legally trained. If you try and represent yourself, people who do that tend to make mistakes, which are not in their best interest. An attorney has experience and knows the law and knows how to proceed in a trial. You can make trial strategies like I talked about. This is a good argument, this is a bad argument. But sometimes those trial strategies, again, could be a mistake. So the question is, you have your right to remain silent. If you choose to testify at trial, you're giving up that right to remain silent. You do not have to testify at trial. The jury cannot use that against you. You've been told what the possible consequences are if you were convicted. Those are big consequences. There will be issues like these motions or other issues at trial that you are not schooled to understand and argue on your own. Ms. Ryder has told me, and I believe that to be a representation of an officer of the court, she is ready to go to trial on the date that I set. She is ready for motions on the date I set. It is your decision whether or not you want to have Ms. Ryder dismissed as your lawyer. That said, you're not going to have a new court-appointed attorney. So you're choosing between representing yourself and being represented by Ms. Ryder, because it's really clear from the cases of the Supreme Court, Court of Appeals, you have a right to a lawyer, you have a right to a court-appointed lawyer, but once you've ginned through a number of lawyers, they say, we've met our burden to provide you a court-appointed lawyer. And that's where we are. I need a decision. Do you want to work with Ms. Ryder, even though at times you may not agree? Even though at times you may not agree on a decision for you to take the stand, a decision to put on evidence, she may tell you it's a bad idea. You may not agree. I can't promise you you're going to agree. But acting in your best interest is her job, whether you like it or not. She will never refuse to put on evidence that you insist that you wish to put on, unless the person's lying, and then we get into other issues, because she can't knowingly put a person on the stand who's going to lie. But other than that, so I understand your position. However, it is a really, really, really bad decision to give up the services of a good lawyer to represent yourself, even if you don't see eye to eye. So, there we are. Mr. Johnson, what do you want to do?
I'll keep her and work with her.
Thank you.
You're right. I can't get up and represent myself in front of. I just don't have the experience, like you said, flat out.
All right. Ms. Ryder, you are on the case for the remainder of the case, whatever the remainder of the case shall be. I assume that you will continue to give your advice, which he may or may not like, and he may follow it or not. And I assume that other than putting on a witness to lie, you will listen to your client's instructions, whether they're in his best interest or not. Ms. Ryder.
And thank you, Your Honor. And based on Mr. Johnson's statements under oath to the court today, I assume that he now intends to respond to my emails and will provide me with information about the witnesses or evidence that he has so that I can prepare his defense.
Okay, that's a reasonable request.
Yes, it is.
Okay, and if you don't give her what she needs to know, she can't represent you well. Okay? Now, it may be that you have some internal reason that you don't want to give that up. Just understand that ties her hands as to representing you well. If you were someplace for some, let's take a hypothetical. You were someplace for some bad reason, okay? Whatever the bad reason may be, committing a theft. But somebody tells a police officer and you get charged with committing an assault on the other side of town. Would be in your best interest to tell her you committed the theft. And that's where I was at the time. I wasn't committing this over here. Now, she doesn't have to tell anybody you were committing the theft, or she may. Do you understand that?
Yes, ma'am.
Okay. You have to be absolutely honest and straightforward with her so she can represent you. She's not going to tell anybody what you tell her unless it's in your best interest, or it helps your case. That's her job. Your job is to trust her because that's her job to help you. Okay, Mr. Tingley, we're going to listen to this doctor when the doctor comes, correct?
He's here.
He's here.
Oh, perfect.
He's in the hall.
All right, let's do that.
I'll get Dr. Hyden.
All right, thank you. Mr. Johnson, if you'd stand back up. I'm sorry I have to ask this, okay? And I apologize for the fact that I have to ask this. Have you had any drugs or alcohol today?
Not me, no.
Okay, not you. Are you sure of that?
Yes, ma'am.
And under penalty of perjury, do you tell me that you have not consumed drugs or alcohol today?
Yes, ma'am.
All right. And do you fully understand what has happened today?
As far as what?
As far as you deciding you're going to go ahead and proceed with Ms. Ryder?
Oh, yes, ma'am.
Okay. Anyone made threats or promises?
No.
All right. Thank you. Go ahead and have a seat. The question became who of a couple of people had engaged in inappropriate behavior before coming to court. I wanted to make sure that Mr. Johnson was not that person.
Right narrow.
Okay, and so we've accomplished that. I think that's consistent with what the officers have told me, that of a couple of people, it was not Mr. Johnson that was the problem. Was not the person who had engaged in behavior that they shouldn't have engaged in before they came to court. So, it's consistent with what the deputy impressions were. I believe Mr. Johnson for the record, and I believe that it's knowingly and voluntarily that he remained with counsel. Now, doctor, if you come forward. Raise your right hand. Under penalty of perjury, do you swear or affirm the information you're about to give in this court and cause shall be the truth? Have a seat, please. Ms. Biggs, can you pretend my jury that we are again running behind, and I will get to them as soon as I can. But they could probably go on break for 45 minutes.
I'll take a minute.
Okay.
I see the name for that witness first.
What's your full name? Spell your last name.
Andrew Ross Harbison, Harb as in boy, ISON.
Ms. Ryder.
Thank you, Your Honor. It's Dr. Harbison, isn't it?
Yes, it is.
Okay. What's your training, Dr. Harbison?
I'm a board-certified internist in internal medicine.
And what does that mean that you've had in the way of training?
What that means is I've had 1 year of what's called internship, which is pre-training prior to residency, and then 2 years of training in internal medicine solely. And then the board certification implies that I've passed a test and met the requirements of the certifying body.
And how long have you worked as an internist?
So I've worked as an internist since 1997.
In lay terms, what does that mean that you do?
What that means is that I practice what's called general internal medicine, which is basically adult medicine. So it's all aspects of medicine pertaining to adults.
Where are you employed?
I'm presently employed with the Rose City Urgent Care and Family Practice Clinics in Portland, Oregon, in the greater Portland area.
And are you familiar with the medical history of Matthew Mayfield Johnson Jr.?
Yes, I am familiar as available in the records in that facility.
And did you have a chance to look at those records in the fall of last year regarding some diagnoses that were made?
Yes, I did.
And what did you see in those records?
What I saw in those records was that a diagnosis was made of diabetes mellitus type 2 sometime in the spring, particularly sometime in early May or late April of 2014.
And as a result of that diagnosis, was any particular course of treatment prescribed to Mr. Johnson?
Yes, a medication was prescribed, specifically a medication called metformin.
Say it again.
Metformin, Metformin.
Thank you.
And during May of last year, was Mr. Johnson taking metformin?
Yes, to the best of my knowledge, he was.
Just to clarify, were you the prescribing physician?
No, I was not. Yes, this was prior to my employment with the facility. His provider at that time, his primary provider at that time, had prescribed the medication.
Specifically on May 16th, 2014, was Mr. Johnson taking metformin to the
Yes.
rest of the year? He was under prescription.
By
for
the review of
metformin.
the records, yes, he was.
Was
It was under prescription, but you don't know specifically if he was taking it or not?
I can't say specifically that he was taking it, but he certainly was prescribed the medication, and I can confirm that the medication was obtained.
Okay, thank you.
Thank you. Are there, have you had a chance to review medical records from Salem Hospital regarding his treatment just after his arrest on May 16th, 2014?
Yes, I did.
And what were the symptoms that led him to be taken to Salem Hospital?
Nausea and vomiting.
Was the diagnosis of diabetes by another physician accurate?
At the time of his emergency department evaluation, the diabetes diagnosis stood. The reason for that is the emergency department's physician ability to diagnose type 2 diabetes mellitus under the circumstances when he saw Mr. Johnson was not possible.
And I'm sorry, I want to make sure we understand your answer. Are you talking about the emergency room at Salem Hospital, or are you talking about the urgent care clinic in Portland?
So, as I understand the question, you want to know whether or not the emergency department physician at Salem Hospital was able to diagnose type 2 diabetes mellitus on May 16, 2014. Is that correct?
No, I'm sorry, and it's probably my inartful question. Is it your belief that the original diagnosis of diabetes and the decision to prescribe metformin was an accurate diagnosis?
No, I do not believe it was an accurate diagnosis nor an appropriate action.
And if one is prescribed metformin when one does not have diabetes, what is the body reaction?
So, the body reaction to someone, whether they have diabetes or not, is not substantial. In other words, the effects of metformin on somebody who does not have diabetes is, for the most part, no different than somebody who has diabetes. However, the adverse effects that are related to metformin can be seen in both people who have diabetes or do not have diabetes, if they're taking the medication. Does that answer your question?
And what would those adverse effects be?
At least a third of people who take metformin have gastrointestinal adverse effects. And of those, although there aren't percentages, nausea and vomiting can be substantial.
And that sort of nausea and vomiting might interfere with their ability to understand what's going on at any given moment.
I would say that to the extent that they're being ill and the experience of being ill would potentially impair somebody's ability to act, shall I say, clearly.
Right, thank you. Nothing further.
Thank you. Have you ever actually met with the defendant, Mr. Johnson?
And meeting in what type of
In
circumstances?
medical setting?
Yes, I've met with Mr. Johnson frequently since the summer of 2014.
And how did so since summer of 2014, that's when you realized it wasn't diabetes?
Yes, I took over Mr. Johnson's care in summer of 2014 when I began working for the facility that I described earlier.
Okay, what's he prescribed now, and what is the diagnosis?
Yeah, there is no diagnosis now. In retrospect, if I'll go into detail if necessary, but I believe that the diagnosis of type 2 diabetes mellitus was actually incorrect.
Did he have any health problem?
No, as far as type 2 diabetes mellitus, no, he does not have a health problem in that regard.
Okay. Yeah, you weren't at the hotel on May 16th, 2014?
No, I was not.
All right, would this nausea cause people to engage in sexual behavior?
No, yeah, this is primarily an isolated impact on the body's perception of gastrointestinal distress.
What about to send text messages, that sort of thing?
I would say that actions can still, in other words, the person's ability to act are not necessarily impaired, but as I said earlier, whether those actions can be claimed to be of clear mental faculty, I would argue that's possible that they were not being done under clear mental faculty. As I said, based upon what I would consider a common sense experience of people, for most people who have experienced the nausea and vomiting and what that sensation is like and how that might impact the ability to think clearly or act clearly.
All right, would marijuana benefit, or I guess help that nausea and vomiting condition?
Yeah, marijuana has been shown to actually improve nausea. It can improve nausea. The mechanisms by which are pointless to go into, but yes, it could.
And so someone taking it wouldn't, because it's caused by the medicine, there wouldn't be an adverse effect with those. So I know sometimes
Would they
nicotine
interact?
medicine.
No, to the best of my knowledge, no, they wouldn't. Some of the evidence I've reviewed suggests actually that the use of marijuana for symptoms of metformin, nausea, and vomiting is not effective.
Is not effective?
Yes, but that's, of course, under clinical circumstances.
Okay. And have you had people in your office who are experiencing the nausea and vomiting?
I have had people in the past, not present, but yes.
And were you able to have communications with them?
I was able to communicate with them. The circumstances under which I saw them, they may not have been acutely nauseating, having acute nausea or vomiting, but certainly they were able to speak with me. I've had people who have had nausea and vomiting, however, not necessarily related to metformin, who have had difficulty expressing their thoughts clearly, mainly because they felt ill. But with time, I would say that depending on the circumstances, I would say it would depend on whether somebody could speak with me clearly about a subject or not under the circumstances of those symptoms.
You weren't at Salem Hospital immediately after this?
No, I was not.
Right. You weren't there the day that the police interviewed the defendant?
No, I was not.
Right. So you don't know how he acted that day?
No, I do not know the specifics of how he acted, yes.
Has anyone ever been untruthful with you in order to seek drugs?
I cannot verify that. I suspect it, but I cannot verify that.
I have nothing further.
Ms. Riley.
No redirect.
All right, thank you, Doctor. I appreciate your coming. You're free to go.
Certainly.
All right, just for the record, I want to say that basically this is the beginning of the motions hearing, and So this testimony is part of the motions hearing. So we've begun the motions hearing, but the rest of the motions hearing, because I had a trial that went over through hopefully very little fault of the court, we have to continue on a different day.
And Your Honor, I'm asking the court for just leeway for a moment for me to put on the record that 3 motions have been filed, just so that we clear the record.
Okay?
3 motions have been filed. One of the motions is a motion to dismiss for lack of proper venue. A second motion is a motion to suppress regarding a search. And a third motion is a motion to suppress defendant's statements. This testimony is applicable to the third motion. I believe it has no applicability to the first 2 motions. I just wanted to put that on the record so that we're clear, since we have 3 motions.
Okay, perfect. All right, that is what we're going to do today. Mr. Johnson, continue to comply with your release agreement and try to get Ms. Ryder the information she believes she needs to represent you well. This case is going to go to trial. We all know that. This case is going to go to motions. We all know that. So let's all share information so that all the information gets on the record if that's appropriate. Okay? We're in recess.
Thank you.
No. That's what,
Thank you guys for watching. Until next time, as you see, Douglas Hanson and his officers, Gail Ryder, Susan Tripp, they all was in cahoots. But there's way more evidence to produce. So you guys have a blessed night. And thank you guys for watching.